Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Cant, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Cant, your trusted attorney advisors in safeguarding what matters most. All right, welcome back to episode 2 of the Smart Legacy Podcast, where we talk about wills, trust, estate planning, and elder law. Sophia Cant, partner attorney, has joined us back in studio. I'm Glenn Stockton, managing attorney of the firm of Stockton & Cant here in the Kansas City area. I would encourage you to subscribe and share our podcast. You'll find it on Spotify, Apple Podcasts, and YouTube. You can also find the platforms on our website at stocktonlaw.com. So please subscribe and share to this. We're going to try to cover relevant estate planning topics and elder law topics, from Medicaid planning, estate planning, how to avoid probate, all of it. So Sophia, last time we were here, we ended up talking about probate, and we focused primarily on probate at death, but we also got a little bit into, we talked about, as I call Terry Schiavo, and the kind of that situation where she was still alive, which also played in the probate court. And we want to go into that a little bit more detail today.
Right. I say, before we go into the probate upon your life still, why don't you give a recap of the definition? What is probate?
Yeah, so I mean, last time I think we gave 3 different definitions, right? But if I really gave, when I talked about the function of probate, I was talking about function of probate and the definition of probate when someone dies, right? So the function was to take assets that are titled in the name of somebody who's deceased and retitle it to the name of somebody who's alive. That's what the function of probate is at death. But probate court also comes into play if we're alive, but we're unable to make decisions ourselves. We become incapacitated, whether it's a stroke, a dementia, Alzheimer's, aneurysms, whatever the case is. We've lost the ability to make decisions ourselves or to care for ourselves. We will be in probate court for what's referred to as living probate, conservatorships, guardianships. So,
and I think most people have heard the word guardianship before. And typically when you think about guardianship, you think about a minor child. The parent is no longer able to care for them, and so we're in court getting a guardian of a minor child. That is probate. What we're talking about today is probate and guardianship for adults. Where we see this happening often is, when an adult has dementia or, they start to lose capacity, then that's when we're in guardianship and conservative in probate court. What is guardianship? So guardianship, that's where we go to court and we are asking the court to appoint somebody to manage our affairs, our personal affairs. And so that would be, filing taxes on our behalf, just anything and everything that we can do as a person they're doing. So back to kind of what people are familiar with, guardians for minor children, right? The guardians are choosing which school they're going to go to, who their doctors are going to be, all of those things. That's what we're doing for adults. That's what guardianship is. At the same time, we have conservatorship. And what conservatorship is, it's very similar, but it's now the court is appointing a conservator to manage the person's financial affairs. So those both go hand in hand, and we often see if somebody needs a guardian, they also need a conservator at the same time.
Yeah, and I think most often it's the same person appointed both roles. It doesn't have to be, but guardians, they're in charge of managing the person, right? So if you need a guardian, they're managing you, your health care, decisions, where you live, make sure you're properly clothed, all that, right? Conservator, they manage your property, your money, as we go in. And it's for people who haven't planned in advance, right? There was no plan, and now the person is incapacitated. That's typically where we're going to see conservatorship, guardianships come into play, but we're going to be in the probate court. That's the court that's going to issue those orders.
Right. And who gets to decide who that person is too, right? You didn't plan ahead. You didn't make that decision.
Someone wearing a black robe, a judge is going to decide who's the appropriate person or people to make those decisions on your behalf. And I would say most of the time they're comfortable with the person who comes forward, but there's often family disputes. Remember we said the number one reason people do planning, we talked about this last time, was I don't want to be a burden. And number two, we don't want family arguing and fighting about things. And if we didn't plan in advance on this stuff, if we didn't make these decisions and we're leaving it to those that we love, those behind, to have to decide this for us, we're absolutely created a burden for them. They're going to have to file annual accountings every year. They got to go to court to even get this thing started, but they're going to file annual accountings because we didn't do the planning. And oftentimes, unfortunately, we do see fighting. There's different people, they disagree with decisions being made or who should be in charge. You don't see it a ton, but we'd certainly see some fighting there as well.
And it gets expensive. It's an expensive process, not typically something that someone wants to be involved in.
Yeah. So we don't, I don't think people really think about that as probate, but that is what we call living probate, going through the probate court.
Right. So share a story about, we've had a client previously who they were involved in, and they unfortunately had to get involved in guardianship a lot sooner than they expected.
Yeah, we talked about this earlier, and this was a case. It wasn't that many years back. It was spring of 2020 because COVID. We were in the midst of COVID. It was we were into it. Everything was kind of shut down, and this was a couple here in the Kansas City area, husband and wife. They were out working in their yard, and wife had a massive stroke. Husband called 911, and the ambulance came and they took wife off to the hospital, and husband got in the car, in following, to get to the hospital. COVID was going on. So when he got to the front doors of the hospital, he was stopped, right? They weren't letting people in.
Wow.
So they got some information about him and contact information, said somebody would be reaching out. He was still there at the hospital in his car in the parking lot when the social worker called. And social worker got a little bit of information about the wife, asking questions about that. And then he was asking how she was. And he said, well, the social worker asked for, whether she said she needed copies of the living will and the powers of attorneys and, and the HIP authorization. And he said, well, unfortunately, we haven't done that. We've talked about it. We know we need to get the plan done, but we haven't got around to doing it. And the social worker had to tell husband, I'm sorry. I'm very sorry. But unfortunately, under the law, I can't even talk to you about how your wife is doing. She hasn't given you authorization to receive this information. And so unfortunately, you're going to need to seek the services of an attorney to help you with this. So he reached out to our office, and this was an afternoon, late afternoon by this point. We were able to file for emergency orders to have husband appointed as the guardian and conservator. But the judge did not sign those orders until the next morning. I've also often thought about the stress that he was under. His wife, massive stroke. He's not able to get information on how she's doing. Nothing coming because he didn't have a simple document called a HIP authorization. Right. I mean, simple. And so we had to go through that probate process. And while we were able to get it done fairly quickly, we filed that day, but it was late, and so the judge did not sign it till the next morning, and it was just a lot of stress that could have so easily been avoided. So people, they sign these HIP authorizations. We go to the doctor's office, the dentist, kind of seems like a pain sometimes maybe to fill it out, but this stuff matters.
Right, and I think that people don't think about it as an estate planning document. And what I find as well in talking to people that, when we talk through who's going to make healthcare decisions for you, well, of course my spouse is going to do that. And we've always talked about that. That's what's going to happen. But they're not thinking through that when you get in that situation, that could be the result is that the hospital staff and the doctor is going to say, I'm sorry, I can't share that information with you. And just because you are married, you don't have the permission, the hospital doesn't have the permission to share that information with you. And I think that shocks a lot of people. They don't understand that. So
yeah, and it is unfortunate to see it. And you're absolutely right. Most people, I think most attorneys don't think of a HIPAA authorization as an estate planning document. I mean, obviously we give HIPAA authorization to the agents under a healthcare power of attorney, but they don't look at the separate HIPAA authorization or HIPAA release form as being a estate planning document, and it's often missed. And so I tell clients, and I know you do the same thing, we want to make sure that we're talking about this. As I tell clients, if you go in the hospital, maybe you're still making your own healthcare decisions, but who do you want to be able to call up and talk to the doctors and talk to the healthcare professionals? You're making your own decisions, or maybe you've appointed your spouse or somebody to make decisions if you can't. But are there other people that you want to be able to talk to the doctors and get information, know what room you're in, how you're doing? I say maybe you're making your own decisions, but you're resting or you're off getting testing done. Do you want the kids to be able to call up and say, hey, how did mom do last night?
Right.
How did dad do? And so, when you do a HIPAA authorization, you can list as few or as many. And we often they want their clergy listed. They want the kids listed, their daughter-in-laws, son-in-laws. They're not the ones making the healthcare decisions, but they want them listed on the HIPAA authorization. And that at least gets them the information.
Right. And what we found is that if you don't have those documents, you very well can end up in probate court. So that's that probate, we talked about it, death, and now during your incapacitation, and who gets to decide who is appointed and, who manages your affairs. Well, the judge gets to decide that. And so, that's what happens if we fail to plan. So I think from here, I'd like to go into a little bit about, okay, we failed to plan. What are really the three types of planning options that we have?
Yeah, so I mean, if we have not, we've not done any formal planning whatsoever, right? The state has a plan for us. Whatever state you're living in is going to have a plan in place for you through guardianships and conservatorships if you're still living. But at death, they're going to have a plan of where your assets go.
So that's that plan number one.
Right. Plan one, we failed to plan. We're under the laws of intestacy. You died intestate, just meaning we died without a will or a trust. And we're going to be in probate court, and the laws of the state we live in are going to govern who gets what. And so, as a way of kind of illustration, let's take a husband and wife, married couple with 3 children, and to kind of keep it simple, I like to use the example. I've got high school sweethearts, husband and wife, married very young. This is actually, a situation your mom and I and you kids, right? I've got 3 kids, and Tamla and I married at a very young age. So what happens, husband has a stroke and, or whatever the case is, he's got to go to the hospital. Well, we got to go conservatorship, guardianship, as we just talked about. What happens at his death? Well, he did no planning, so the state has a plan in place for him under the laws of intestacy. He died intestate.
Why don't you share what it is in Kansas?
So in Kansas, if husband died and there's no plan in place, spousal shares 50%. So half the assets are going to go to the spouse. The other half divided equally among the kids. And
I don't think people want that. I mean, how often do you have people come in and they say that's what they want?
Yeah, typically not. Typically they want to go to their surviving spouse first. The kids got to wait till they both die. But under Kansas law, 50% to the spouse, 50% to the kids. Missouri, the spouse comes out slightly better. I think it's $20,000. The wife gets the first $20,000, or spouse gets the first $20,000, and then 50% of everything thereafter. And then the other 50% is divided equally among the kids. And most states have some variation of that, where the spousal share is close to that 50% mark, at least all the states I'm aware of. But certainly here in Kansas and Missouri, with that slight variation, we're guaranteed we're going to probate court. Spouse is going to end up with half. The kids are going the other half. If our goal was not to be a burden, again, we've kind of blown it. We're in court. And those probates, because we're under the laws of intestacy, those probates tend to be the most complicated. They're the ones that take the longest. They're the ones that end up being the most expensive. They're the ones that lead to the most arguing and fighting. And but that's the state plan, and we're going to court. We get no say-so in who gets what. The state law is going to decide it. Now, I will say, if there is no, children, then the spouse will get everything. If there's no spouse, then it gets divided equally among kids. If there were neither spouse or children, let's say it gets complicated, but the state has a plan. But then think of what about in the blended family?
Yeah.
Well, your stepchildren, they are not included. It's your biological children that come into play under that plan. Children, maybe you gave a child up for adoption, they come into play. They are an heir at law.
And not only do they come into play, probate's public.
Yeah.
It's anybody can see what's going on. That that nosy neighbor down the road, they know what's going on in your case. It's completely public.
Yep, absolutely. And we see lots of issues that come up with that.
Right. And we've seen celebrities who they don't have an estate plan in place. They've got millions and millions of dollars, and everyone's watching that online. But even for us normal people, I think that's important to realize, is that it is a public proceeding.
Well, and we're seeing, unfortunately, and I talk about this frequently when I'm talking to people about this process, we've seen an increase. This wasn't even on the radar screen when I first started doing this, but it's the scammers. Because it's public process and there's a creditor claim process through the probate court, we see claims filed that are, fraudulent claims. And these scammers, they're smart about it, right? It seems legitimate. They file the claim, hoping to get a payday, but they're smart about it. They file it big enough to make it worth their while, but not so big that you're likely to really fight them, at least not very hard on it, because by the time you pay the attorneys, go to court, challenge it, the kids were, cheaper just to open up the checkbook and write the check and pay the bill.
Right.
And so they'll try to negotiate it down. And the scammers know that, so they're smart about it. And the kids just want to be done with this. It's already been such a big burden. They don't want to have to go in and fight this. And again, with them knowing that, we've seen an increase. The courts are trying to figure out how to stay ahead of this on top. But it always seems like scammers are, always one step ahead.
Right. Yeah, and we see this all the time. So number one plan. No plan. Yeah,
no plan under laws of intestacy.
Right.
Number two plan, if we're going to do is right. So hopefully everybody can agree, failing to plan should not be an option, right? It's there. If we don't get around to doing it, the state has a plan in place for you, but it's going to be the most expensive, the most complicated, it leads to the most fighting, the biggest burden, and not going to end up the result you want,
right?
In all likelihood. So we should not rely on that plan. So if we're going to do planning, we're either going to use wills or trusts. So plan number two, let's look at wills. We're planning with a will. And we're all familiar with wills and specifically the last will and testament. What is it? Well, it's a formal legal document that answers the question of who gets what at death. It's also the document if we had minor dependent children, where we would typically name who we want the guardian for those children to be.
Mm-hmm. Yeah.
Guaranteed we're going to probate, right?
Yep.
Wills, by their very nature, go through probate.
Yeah.
If we think about it, we knew that.
But this time it's a little bit different.
Yes, right.
This time we've made those decisions ahead of time in the will, right? Who's going to be the executor, the personal representative, who's going to manage everything in the estate. The judge now has to approve of it, but you've selected that in your will. So that's really what that will document is. It's just you telling the probate court what they should do. Right.
If we go back to, last episode where we defined probate, and I said, what's the function of probate? To take assets from that are titled in the name of somebody who's dead, retitled in the name of somebody who's alive. That's what the probate court does at death. Well, the will tells the court who gets it, but how do we get the kids' names on the home or on the accounts? Well, that's what probate court does. But before the court will appoint the executor or authorize the distribution of the assets, retitling them to the kids, the court requires that a notice be sent out to all the beneficiaries under the will, as well as all the what we call heirs at law, the people that would have taken under that do-nothing plan. Why? Well, maybe one of them comes forward and say, wait a minute, this will, that's the, 2001 will. There was another one done in 2021 that superseded it. Or, wait a minute, my mom was under undue influence when she signed this will, or she was incapacitated, or, whatever the case is, people have the opportunity to challenge it.
Right. I'm just thinking through that process, even what a burden to, on the family who they've got to figure out names of all, hopefully they know names of all the children, maybe not, addresses, and then all the potential heirs too. That's a lot of work on their plate. And not only work of finding that information, working with an attorney to do that, but also now the cost of mailing out those notices. So,
but most of the time the court finds that the will's valid, and they appoint the executor that the person chose, because with a will you get to choose who's in charge. Under the do nothing plan, you had no say so in it because you didn't plan. But here you get to choose. And with a will, remember on the do nothing plan, 50% to spouse, 50% to the kids. With a will, you get to choose who gets what. So you can say everything to my spouse survives me. If my spouse doesn't survive me, then divide it equally among the kids. You could leave it unequal. The kids. You could say, gosh, I've helped this kid out more during their lifetime. I'm going to treat that as a pre-inheritance, and I'm going to do an equalization payment to these kids to kind of get them the same level so they're all treated fairly, and then divide equally. With a will, you can completely disinherit a child. Can't do that under doing it. You can leave to somebody other than children. Can't disinherit your spouse unless your spouse consents. They're entitled to at least that 50% spousal share. Right. But, you could disinherit a child. You could leave to somebody other than spouse and children. You could leave to grandchildren, nieces, nephews, anybody you want. As I like to tell people, I would suggest you can leave it to your favorite attorney. Most people don't take me up on that one, but nobody has yet. And I'm being facetious. But the idea is with the will. Charities. You get to choose who gets what. You get none of that say-so under the do nothing plan. But you're going to go through probate. We're not avoiding probate. Wills, by their very nature, have to go through probate.
Right. And back to, again, all the things we talked about probate, right? It being public as well. It's back to that again. But now, right, you've made the decisions.
If somebody came to me and said, Glenn, my only goal is to avoid probate at death, right? Now, that's never the only goal. But if somebody did have that, it's back to what we said last time. Don't overcomplicate this stuff. Keep it simple. So if somebody came and said, that's my only goal is to avoid probate at death, I said, well, that's easy.
Yeah.
And we can use beneficiary designations. Beneficiary designations are a statutory mechanism that is a non-probate transfer of assets. And so if somebody wanted to avoid probate, we could use beneficiary.
Do it on pretty much everything, right?
Everything.
Bank accounts, your vehicles, your house, your retirement accounts, your life insurance policies, virtually everything you own, you can put a beneficiary on.
Yeah. So with the bank accounts, we call that a POD, pay on death designation. The home and vehicles, transfer on death, or TOD, at least in Kansas, Missouri, on the home or other real estate, we call it a beneficiary deed. But it's the same thing. It's just a beneficiary designation. You probably already have, if you've got IRAs, life insurance, you've probably already set up beneficiary designations on that. So, back to the do nothing plan, it's actually pretty rare that it would come in that somebody had absolutely nothing in place. Even if they haven't done formal estate planning, they usually have, some of these beneficiary designations and at least some of the assets set up. And that's going to go in accordance with a beneficiary designation. And if there's a will, it doesn't matter what the will said. If you had a beneficiary designation that said something different, that beneficiary designation for that asset is going to control.
Right.
And the other thing that factors into this is joint tenancy. And I tell people, you can think of joint tenancy as last one standing wins, right? So, and this factors in a lot of cases. Married couples often own property together as joint tenants with right of survivorship. They own, their home was joint tenant, right of survivorship. They have joint checking accounts, maybe joint investment accounts. And so, if one spouse dies, those assets, as long as the other spouse did their part and they're still alive, we're not going through probate.
Yeah.
But it delays probate because what happens at the death of the second? Well, now we're back to the do nothing plan if they've done nothing more.
Right.
So these things factor in, but we need to make sure they're coordinated, because how many times have you run into the situation where, they want the assets go, to their kids equally, and that's what their will or even trust says, but then you get into how it's titled or how beneficiary designations are set up.
It's never done at the same time and the same mindset either. Yeah, always very different.
So it's part back to, in our firm, our goal is to be that trusted advisor for our clients, to be one of the very first calls our clients or loved ones make. In order to kind of accomplish that, we like to meet with our clients on a regular basis. We do the annual review process. And one of the things we're looking at, we always confirm plan choices. Here's who you've named to make healthcare decisions. Here's who you've named financial decisions. Here's who you've named as beneficiary, that type of thing. Is this still the people you want? How's everybody getting along? How's your health? How's their health? We're going through all that. But then we look to the assets. We're going through, here were your bank accounts, cash accounts, money market, CDs, checking, savings. Here's your non-qualified investment accounts, your brokerage accounts, stocks, bonds, those kind of things, I-bonds, whatever you got. Oh, here's your retirement accounts. Here's your life insurance. Verifying, do you have any, lock boxes at the bank, storage units, long-term care policies. We're just confirming, because people often be like, oh gosh, no, that life insurance policy went away. Well, get it back out there. It just confuses things for those we leave behind.
Right.
Oh, I opened up a new account. Great. How did we title it? Give me a copy of this statement, and let's put it in this report. We use the Excel spreadsheet. It's our way of keeping track how it's titled, how it's taxed, who the beneficiaries are. But we want to keep this stuff up to date to make sure that it's coordinated.
And I think it's important, just kind of on that note, that report, and making sure that back to not being a burden on our family and on our children. Likely, most of what you have at this point. I know oftentimes I meet with people and we find out, oops, they had a life insurance policy that they got a long time ago. They forgot about it and whatnot. But it's a good time to revisit that as well and figure out, okay, now I found out I do have that. Put it down. Get it in a place that's organized where people that need to know about it will be able to know about it. Figure out, get those statements, figure out, contact them. What are the benefits? Who are the beneficiaries you've designated? How are they titled? So many times we see those and they're not titled the way that they thought they were titled. So I think that report that we do and is something that is important for anybody to have and to stop and spend time and organize.
Yeah, and it's, as I tell clients, when I see a statement, as the attorneys, we like to see the original source document. You can tell me it's titled to you and your spouse, or it's titled in the trust, or whatever the case is. But I always say I'd like to see the document, because when I see a statement, I know how it's titled. I also know how it's taxed. Based on what type of account it is. And we're always paying attention, because it's one of those areas, we talked about how people are not planning for long-term care. The other thing we see, people are not thinking about taxes. How do we minimize the impact of taxes? And as we like to say, small hinges swing big doors. It's usually small incremental things we're doing on the taxes to minimize the impact and planning ahead of this stuff.
And I think when people on taxes, when they work with CPAs, they're thinking about how can they save the most taxes right then and there. But they're not thinking about here in the future, how can I minimize the impact of taxes?
No offense to the CPAs and tax preparers out there, but often say they're great historians, because typically what I find, and there are certainly exceptions, and if you've got one of these, CPAs or tax preparers that is thinking ahead, kind of playing down the board, fantastic. They're gold, because most of them aren't. They're taking whatever you did in the prior year and they're putting in the tax returns, and maybe they give you idea for next year, but they're most of the time we're not seeing where there's any long-term or strategic tax planning. And that's what we look at our role for our clients to come in and say, hey, we're not your tax preparer, but can we help you get there? Sophie, I do want to go back to one thing you said. You talked about the life insurance, and this is something that in my view, it's one of these things that gets missed often. It's on those older policies. A lot of those older policies, there's some sort of, if they're older policies, those are often some sort of permanent life, right? Maybe they have cash values or something in there, some sort of permanent life. And those policies were issued under some assumptions that didn't necessarily hold up. They thought interest rates, they were maybe purchased in a higher interest rate environment of the 70s, 80s. Into the early 90s, even mid 90s, when interest rates were higher, and they made some assumptions, and the policies were based on that. But we went through 2 decades where we had very, very low interest rates, and those policies did not live up to expectations. So what we like to do for our clients is they have those, let's get what we call an in-force policy illustration. You can get it through the agent. There's different companies we can send to. Doesn't cost them anything to get done. But let's just have them reassess that policy and say, is it going to live up? Because we've got some horror stories where people had these older policies and then they got to the point later in life where they were getting close to the time they need it, and all of a sudden there's huge premium increases because the policies failed to follow through and the people have lived longer than maybe was expected. So make sure that you're just looking at this stuff. It's why we like to do our annual review process.
Right. So we talked about the do nothing plan. We talked about will. A will by its very nature has to go through probate. What's the third plan?
All right. So trust, right? And you and I are both huge fans of trust. There's so many things I can do with a trust that cannot do with a will, can't do with a beneficiary designation, can't do with powers of attorneys, those kind of things. But we can darn sure do it with a trust. And there's lots of types of trust. There's revocable trust, irrevocable trust, special needs trust, deferred sales trust, irrevocable life insurance trust, all kinds of trust. By far, the most common type of trust we have is the revocable living trust. And for a married couple, typically the joint revocable trust. We don't always need one trust for husband, one trust for wife. Regardless of what kind of trust we're talking about, we like to tell people, think of a trust as being like a legal safe. We're creating the safe that is the trust. The person or people that create that trust, we refer to them as the grantors. Sometimes we refer to them as the trustors. Sometimes we refer to them as the settlors,
makers,
donors. Trust makers, the term I like, right? I'm back to functional child, like the functional definition of probate. Well, it helps us understand what it is. Trust maker helps us understand, what a grantor, trustor, settler, donor is. But we use all those terms. That way they need us attorneys, right? We got to keep ourselves relevant. We got to be in need. We use all terms. But trust maker, it's just the people who create it. So back to my husband-wife situation that I had, high school sweethearts, 3 kids. They decide they're going to create a trust, right? A joint trust. So they create this safe, this, what we call a trust. They're the joint trust makers. Typically, with the revocable trust, they're also going to keep the keys of the safe. They are the co-trustees, so they each have a key to the safe, to the trust, right? Just like they had with their joint checking account, right? Either one of them could write checks. Either one of them could make deposits. Either one of them can make withdrawals, and they didn't need the permission of the other. One of the spouses could go down and pull out every last penny out of that checking account. Right. Same thing with a trust. They have joint access, but power to act independently. So we've created the safe, we've given the keys to them, we get a name who has the backup key.
Right.
And this is one of the beauties of the trust. We're not going to need probate, right? Because now we can say, okay, let's say in our situation, kids all get along great, and we've decided the 3 kids are going to be co-trustees. And what we find, transparency goes a long, long way in keeping the family peace. And, we could put just one child. We could appoint somebody other than the children. But let's say we've appointed the 3 kids. They're the co-trustees, power to act independently again. Yeah. And we don't want to be a burden. We don't create a situation where I'll have to countersign checks and be on every phone call. So we've given them the backup key. Then we have to do what we call fund the trust, which just means we got to get the assets in the safe. Yeah. So,
and this is what we see fail all the time. In fact, how often do you meet with somebody who comes in and they say, oh, I already have a trust. And you say, great, let's review it and make sure it's funded properly and everything's, all of your assets are titled properly into the trust. And how many times is that already done?
So, Sophia, this is interesting to bring up. We talked about last time, when the firm started being in the, the basement of the First Kansas Bank and Trust building out in Carter. I think I was a year into my practice, or a little over a year, the first time I saw fully funded trust. In fact, the majority of the trusts I saw early on, maybe the home was in it, but that was it. Nothing was in the trust. And so I remember questioning, saying, okay, maybe this isn't it. Why are people, people are creating this, but it's not going to work. None of the assets are in the trust. So that's why we decided, we look at that. That's our job as an attorney. We help with the funding. I want to make sure that we get the assets into the safe, right? We help make sure that happens. That asset detail report's our way of keeping track of it. We do the annual review meetings.
Right. Every year we're revisiting it, making sure, hey, did you buy new property, sell off property? Let's get back to revisiting. I want to see statements again. I want to see that you have actually properly titled it, because so many times too, people will say, yes, they've done it, and they found out is that they didn't do it right. So revisiting that.
And so we'll track it. If they tell me they did it, I put per client the date. It's my way of riding herd on the say, you told me you did it, but I still haven't seen the statement. When I see the statement, I verify. But you just want to look at this stuff periodically. So back to our trust, though. So we got this safe. They've created it, the husband and wife. They're the joint trust makers. They've both kept a key. They're the trustees. They've given the backup keys to the kids. Now we got to get the assets into the safe. We got to title the assets in. So in their home, instead of owning their home as joint tenants or right of survivorship, we transfer the home into their joint trust. Same darn home it was before. Still their homestead, all those things, but
Still
it's now,
living it.
still living it. We have rights occupied. We don't have to redo the mortgage, and we don't even have to notify the mortgage company. Everything goes great. We're good. We do the same thing with checking account. They had that joint checking account. Now it's titled to their joint trust. It's the same checking account it was before. Same checks, same debit cards. We don't have to get new checks. People all the time, well, don't you have to get new checks? No. Not anybody uses checks much anymore. But but no, you don't have to. Not while it's still in that revocable stage, anyhow. While husband and wife are alive. But now that checking account, it's the same account as it was before, but it's now in the safe. It's in the trust, and we're going to do that with each of the assets. But life goes on as normal. They file taxes just like they did before. But we've got the assets into the trust. Now, if they become incapacitated, we don't need to go for the conservatorships, guardianships, right? The assets are in the trust. We've appointed people to make these decisions on behalf. We've given the kids the backup keys.
Right. So when we talk about estate planning, most people think estate planning, the whole point of estate planning is for when we die, who gets what. But they're not. I don't know that they understand that estate planning is for your incapacitation. We talked about probate and guardianship and conservatorship. That happens if we become incapacitated, but a trust can help so much and make things easy and a smooth transition. In fact, there's really not much transition at all. If your assets are funded into the safe, into the trust, and you are managing it while you are living, you become incapacitated, the next trustee, they have the key to it. They have immediate access to everything in the trust. There's no downtime, no delay time. It's there for your benefit. And trust is a really strong document.
Very strong. As we said, we're both big fans of trust. We're just not attorneys that believe everybody necessarily needs a trust.
Right.
As I tell people, if the things that a trust can do for you are important to you, then we need to look to the trust. If they're not important to you, it's back to don't overcomplicate this stuff. Keep it simple. Maybe we'll use a will, well-placed beneficiary designations, and some robust, powers of attorney, so those kind of things to deal with disability. Because we talked about wills have to go through probate. Wills also do nothing for us while we're alive, right? They don't help us if we lose capacity. We're back to conservatorship, guardianship if we've done nothing more than a will. But a trust is a powerful disability incapacity planning vehicle. As you said, if something happens, the kids have continuous, immediate access. They got the backup key, just like a corporation, right? If the CEO of Coca-Cola Corporation were to fall out of his chair with a stroke, Coca-Cola doesn't really miss a beat. They've got an interim CEO that immediately steps in and runs the business while the CEO is out. If the CEO died, they've got the successor CEO that comes in and runs the business. A corporation would be another type of legal safe, if you will. But so think of this trust as a safe. And so we've appointed people, powerful disability planning tool. Upon death, with a will, the spouse would probably have access because there was a joint account, but kids, they don't have immediate access to the money. They got to wait to be appointed the executor by the court. If they used a pay on death beneficiary designation on those accounts, they got to wait for the death certificates. They don't have immediate access. So the kids are often paying for the funeral out of their own pocket, unless we've had a prepaid funeral, hoping to get reimbursed. With a trust, they got immediate continuous access. They got the keys of the safe. They pay from your accounts. When the kid's inherited in trust, it's divorce protected, it's creditor protected, it's bankruptcy protected. Yeah. I don't have the crystal ball to know what's going on in your kid's life. I don't know if they're going through divorce. I don't know. Maybe they opened up a business and a pandemic hit and they find themselves in bankruptcy court. But with a trust, if we've structured this right, when they inherit in trust, it provides protection for them. Completely avoids probate. Why? Well, let's go back to the function of probate. What's the function? To take assets that are titled in the name of somebody who's now deceased and retitle in the name of somebody who's alive, right? Because when they're deceased, it's now part of their estate. Well, with a trust, it was titled in the name of the trust when you're alive and well. It's titled in the name of the trust if you become incapacitated. It's titled in the trust when you die. We don't need the court's involvement there. And one of the other things, and this is one of the things that gets missed so much. And this is what I want to in our next episode when we come back here in a couple weeks to talk about planning for long-term care, because this is one of the things that people miss all the time. We're estate planning and elder law attorneys.
Right.
We always want to make sure what's the plan for long-term care. And there's no cookie cutter recipe that says everybody just needs to go this or everybody just needs to go buy long-term care insurance. We're going to look at what's the best plan for you. But one of the beauties with a trust is we can protect assets from the Medicaid spend down. And we'll get into that next episode. But the problem is, as we said, the most common type of trust we have is a revocable living trust. But most of the time, most attorneys creating these trusts, they don't even accidentally deal with the issue of long-term care.
Right.
And that's so unfortunate because as elder law attorneys, we can build in the revocable trust so it become that trust. And we'll talk next time about how we do that. But we want to build in the flip switch, but they don't even accidentally deal with this. And it's just so unfortunate, because when do people go to see the elder law attorney?
Right, when they're seated at the desk of the admission desk of a nursing home, right then and there, right before it at least.
Yeah, that's when they go see the elder law attorney.
Yeah.
And we're estate planning and elder law attorneys, so we're like, no, let's plan for the stuff in advance. Let's make sure we got a plan in place. If we're not using a trust, then we'll talk about how we can, how we can otherwise work around that to put a plan in place.
Right.
So, all right, so do nothing, go into probate. We have a will,
Right. Go through probate still.
right, but we have a trust, avoids probate.
Right.
Beneficiary designations can avoid probate. So we get that. So that wraps us up here. I would remind listeners, to subscribe and share this podcast. You'll find us on Spotify, Apple Podcasts, and also YouTube. And you can also go to StocktonLaw.com and find our podcast there, as well as the various platforms that we're on. So tune in next time. We're going to be talking about how we plan for long-term care. Thanks again for tuning in.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.